Morning, everybody. Welcome to the First District Court of Appeals. We have 5 cases on the docket today, but 2 have been submitted. The submitted cases are State of Ohio versus Acefa, C220062, and State of Ohio versus Eze, C200429. Those cases have been submitted on the briefs, and we have 3 cases for argument today. The first case that's set to be argued is Klug versus Hillgrove, and that's C220150. And would the attorneys please state their names and their readiness to proceed?
Carrie Wade on behalf of the appellant, I'm ready to proceed, Your Honor.
Okay.
Angela Goebel on behalf of Emily and I'm ready.
All right, thank you. And I'll just state the other cases that will be argued. The next case to be argued is State of Ohio versus Palmer, C220146. And will the parties state their names?
Paula Adams on behalf of the State of Ohio. I'll be filling in for Mr. Springham this morning. I'm ready to proceed.
Great, thank you.
David Hoffman for the appellate, Your Honor, ready to proceed.
Okay, great. And then the final case is State of Ohio versus Pitts. That's C220080.
I'm here for the appellant on that case, Your Honor, ready to proceed.
Okay.
Here for the appellate, ready to proceed.
Okay, great, thank you. All right, well, the parties for Klug versus Hillgrove, please come forward. And each side is going to receive 15 minutes. Ms. Wade, I'm sorry, would you like to reserve any time for rebuttal?
Yes, Your Honor, I'd like to reserve 3 minutes.
Okay. Whenever you're ready. And the lights will show, when you have 1 minute left, the yellow will show, and when you're finished, the red will show.
Thank you.
Okay?
May it please the court, my name is Carrie Wade. I am appearing on behalf of the appellant Michelle Klug. This appeal stems from the trial court's denial of a 60B motion for relief. The underlying issue are 4 parcels of investment property that were not allocated in the parties' decree of divorce. Because those parcels were not allocated, the decree is not final. We are asking the trial court to finalize this divorce by allocating those 4 parcels.
Were they just, what happened with the 4 parcels? I know they were discussed at the trial, but were they just forgotten about, or what happened?
So there were a number of investment properties. Some of the investment properties were titled in an LLC, Hillgrove Investments LLC. There were 6 more parcels that were titled in husband's name. The parties entered into a stipulation that the investment properties titled under the LLC would be sold and the proceeds equally divided. They entered into that stipulation prior to the 3rd of 4 days of trial. During the 3rd day of trial, husband was giving testimony about the parcels only to discuss which ones had been sold and which ones had not been sold, at which point the magistrate interjected and asked to clarify, don't we have a stipulation about how all of the parcels will be sold? To which counsel replied, yes, we do. They will all be sold and all of the proceeds will be divided. No correction was given from husband's counsel or from husband, so the understanding on the record was there was an agreement for all parcels to be sold and divided.
So all parcels were in the stipulation?
The wording of the stipulation was for all of the parcels titled in the LLC, but what was stated on the record was that all parcels would be sold and equally divided.
Ma'am, it looks like the problem here was those 4 parcels were titled in the husband's name only and not the LLC.
Correct. And so the decree is silent as to those 4 remaining parcels. There are no catch-all provisions anywhere in the decree that states anything not specifically divided herein will be and titled in the name of each party will be their sole and exclusive property. There's nothing like that. There's nothing that could be interpreted in the decree of divorce as having allocated these 4 parcels. In appellee's own brief, they acknowledge there is no allocation for these 4 parcels. So because there's no allocation, this decree is not final, and the 60B motion should have been granted.
Well, if it's not final, it's not a final order, 60B wouldn't apply, would it?
It was the mechanism, it was the appropriate mechanism to bring the issue before the trial court, to tell the court that there is an issue with the decree, that the decree needs to be amended to address these 4 parcels so that the decree can actually be finalized.
Do we even have jurisdiction over this case? If you're correct and the decree is not final, then how do we have jurisdiction?
You have jurisdiction over the denial of the 60B motion.
If the underlying judgment is not a final judgment, how would we have jurisdiction?
Ultimately, our goal would be for the Court of Appeals to instruct the trial court to go back and finalize this decree by making an allocation of the 4 parcels. We do believe you have the jurisdiction to do that, to make a ruling on the 60B motion, to instruct the court to reverse their denial of the 60B motion so that the trial court can amend the decree and actually finalize the divorce. At the moment, we're in a state of limbo. The trial court has said we're not going to do anything with the decree. You're done. You should have filed objections, but we're left with an unfinal decree.
Wouldn't this be more appropriate for a motion seeking the court to finalize the decree rather than a 60B?
That was what the 60B was requesting to do, and the
But
trial
the
court.
60B only addresses final judgments.
The 60B, the court disagrees with us that it's not the trial court disagrees with us that it's not a final judgment. They are under the impression that it is a final judgment, and they're not going to do anything about it unless the Court of Appeals tells them otherwise.
Then wouldn't this be more appropriate for a writ?
I disagree. I believe this court does have jurisdiction over the denial of the 60B motion.
If we were to find that we don't,
If you were to find that we don't, then perhaps we could file a motion with the trial court and they would understand the lack of finality in the decree, or we would seek a writ.
So the trial court, what was the reasoning? I mean, obviously you explained to the court that this property was missing from the final decree. What was the court's reasoning why it didn't agree with that?
The trial court was persuaded by husband's argument that because my client didn't file objections to the magistrate's decision, that the argument had been waived and that a 60B cannot substitute for proper objections.
So the trial court didn't say that somehow its order could be read to encompass that property.
Correct.
It pretty much agreed with you that it did not include the property, but put it on your client that there was no objection.
Correct.
Okay.
Correct. So our argument is that the 60B motion should have been granted not only because all 3 prongs of the GTE test were met, but also because the trial court's denial of the 60B motion doesn't further either of the purposes that the 60B rule is supposed to further. The Supreme Court has stated that the purpose of Rule 60B relief is to attempt to strike a proper balance between conflicting principles that litigation must be brought to an end and that justice should be served. By denying the 60B motion, neither of those purposes have been fulfilled. As we've already discussed, it's our argument that the decree is not final based on the exclusion of those 4 parcels, because under Section 3105.171 of the revised code, all assets must be determined to either be separate or marital, and all marital assets must be disposed of in a final decree. And Rule 75F requires the disposition of all assets in a decree in order for it to be final. So by dismissing the 60B motion, we're left with an unfinal order. Additionally, by denying the 60B motion, justice is not being served. If the denial of the 60B motion is allowed to stand and these 4 parcels go unallocated, husband, Mr. Hillgrove, will be unjustly enriched to the tune of $200,000.
Counsel, can you clarify something for me? It's my understanding that your client's trial attorney drafted the decree. Is that correct?
Correct.
Okay.
She did.
Okay.
That doesn't, I will say she drafted it, and Mr. Hillgrove's trial attorney also reviewed it. The mistake that we are alleging under 60B was a mutual mistake. It was not only incumbent on Ms. Klug to make sure that those parcels were included in the final decree. It was also incumbent on Mr. Hillgrove to ensure that those parcels were included in the final decree so that it would in fact be a final decree. He had 4 days of trial to present any argument or testimony that he wanted to suggest that those were his separate property, and he did not. We have 4 days of trial, and there is no evidence presented whatsoever that those 4 parcels were not marital property and should have been equally divided. He had just as much opportunity as Ms. Klug did to file objections or to add them to the decree of divorce. They made a mutual mistake or had a mutual incidence of excusable neglect that should have been corrected with a 60B motion. Back to the failure of administration of justice. There are 4 properties, 2 of which have already been sold. One property sold for $255,000, a second one sold for $25,000, and the 2 remaining properties have estimated values of over $110,000. This is a fairly modest marital estate, so this $400,000 that these 2 marital properties comprise is a significant portion of the marital estate that should have been divided. And if the trial court is not instructed to include those parcels in an amended decree of divorce, Mr. Hillgrove will be unjustly enriched and be the sole beneficiary of this mutual mistake that both parties had an obligation to address and catch, and that both, through an excusable neglect, failed to do so, and it needs to be corrected so that this case can have some finality.
I had a question about that. You said 2 of the properties have been sold. Was Ms. Klug contacted about that? It seems that a title examiner would have noticed that these properties were maybe subject to divorce, and it was just in one. No, she was not contacted, I'm assuming.
I don't believe that she was contacted,
Any
and
rights?
I assume it was because they were titled in his sole name, and it was after, they were sold after, well, do you mind if I
No,
don't know.
it's
I'm
more
sorry, I'm not
academic.
sure if she
Well,
was contacted or
It seems like
not.
there'd be a cloud on the title. The title examiner would have caught.
I would think, I would wonder, but the fact is that they have been sold. The proceeds were, all went to Mr. Hillgrove, and she has not seen any benefit from those proceeds. And as was stated in Mr. Hillgrove, from the email exchanges that were included in Mr. Hillgrove's brief, he has no intention of sharing those proceeds, despite the fact that, again, after 4 days of trial, he presented no evidence or testimony that those properties were his separate properties to enjoy.
And it was acknowledged at trial that they were marital property, right?
There was very little testimony. There are pages 295 to 299 of the transcript, are 5 pages. That's the only place that those properties are ever mentioned. And again, those were only mentioned in the context of which ones had been sold and which ones still remained to be sold. There was no testimony about whether or not they were separate or marital, because the clarification asked of the trial court and given by counsel was that, yes, they were included in the stipulation that they would be sold and the proceeds equally divided.
And that was mistaken.
That was mistaken.
All right.
All right. So, Your Honors, the 3 prongs of the GTE test were met. Ms. Klug clearly has a meritorious claim with there being no evidence that these were separate property, they're marital property that should have been divided. She is entitled to relief under 60B based on mutual mistake and excusable neglect. Both parties knew of the properties and knew that they should have been included in the decree. And she made the motion within a reasonable time. Under 60B1, which is the grounds we are claiming, she had 1 year in which to file her motion for 60B, and she did file her motion for 60B relief within 1 year of the decree being filed. The court abused its discretion in denying the motion because it doesn't further either of the stated purposes of 60B. We don't have a final decree, and justice is not being served by allowing Mr. Hillgrove to retain all of the proceeds of those properties. And for that reason, we're asking that the 60B motion denial be overruled and sent back to the trial court for determination. Thank you.
so much. Ms. Goebel?
Good morning. May it please the court, My name is Angela Meyer Goebel. I'm here on behalf of Appellee Jeffrey Hillgrove. Mr. Hillgrove believes that the trial court was correct in denying the 60B motion for relief. Essentially, his position is that appellant is looking for any type of loophole to attempt to gain the properties that are solely his and exclusively his.
If it's not a final order, though, how is it a loophole?
That it is a final order, and it's our position that appellant is using any position possible, be it the 60B, it's not final, and mutual mistake as a way to change the final order.
Can you explain how it is final? If the trial court did not look at those specific 4 properties and determine whether they were separate or marital property and dispose of them in some way, how is it a final order?
Our position is it is the final order as indicated by the trial court in denying the 60B, that plaintiff appellant was aware of those properties. They were included in her property statement filed originally with the court. They were also included in her exhibits during the trial. They had every opportunity to address those. Our position is Mr. Hillgrove and his attorney asserted that they were his separate property. One of the properties was purchased 10 years prior to the marriage. Another one was purchased prior to the marriage, and the other 2 are very small properties.
Where did he assert that these were his separate marital property? Because that's what I'm trying to understand in the record, where that assertion was made.
He asserted that during the negotiations, when the parties voluntarily entered into the stipulations that they both had counsel with, that they both reviewed, and they both agreed to.
But that's not on the record?
The stipulations?
No, the negotiations where he asserted that it was his separate property.
I'm not sure if that's on the record. I didn't represent Mr. Hillgrove during the trial. I came on post-decree, so I'm not sure if it's on the record. And again, because it's our position that it is a final order and denying the 60B was appropriate, I have not reviewed any of the transcripts in front of the magistrate. Transcripts, if they were interested in those, and our position is she should have filed an objection. She had counsel at the time. Her counsel drafted the decree. Her counsel reviewed everything with her. Her counsel drafted the stipulations.
But I'm still struggling to figure out how it could be a final order. It doesn't matter what happened before. It's the judgment that matters. How could it be a final judgment?
Because everything is complete. It was determined through the trial that those 4 properties were not to be included in the division of marital property, and they were not included. That's our position. They were not included purposely because they are his separate properties.
I think the problem is there's nothing indicating that anywhere in the record, that they were not included purposely. They were discussed very briefly, apparently, at the trial, and there was nothing in any order that said these are his separate property, or, I mean, they just were omitted.
And I can understand that position, and if that's the case, that is the case. However, she had the opportunity to file an objection to the magistrate's decision. She failed to do that. Once the final decree went on that incorporated that magistrate's decision, she also had the opportunity to appeal that decision. She failed to do that.
So even if somehow, I mean, it was clear on the record this was marital property, and this just was forgotten, and she forgot about it, never made it into the decree, nothing was ever done with it, you're saying because she didn't object, she's out of luck,
Correct.
even though it's marital property?
We're not
You're
saying
not
it's-
conceding that, but I'm saying even
Right.
if it was somehow very evident on the record that it was marital property, her failure to object means that she's out of luck. Like, it's now his property.
Well, yes, if you're saying that it is marital property, then yes, that would be our position, that failure to file an objection, failure to appeal the decree, a 60B motion is not the proper way to change a decree if, in the event she feels like something was left out. She should not have filed a 60B. She could have addressed this a different way through the trial court but instead
How
of
would she have done it otherwise?
she could file a motion to vacate the decree. She could have, there are lots of ways she could have attempted to resolve it versus filing a 60B. She chose this route. And, this is where we are, but we don't agree that this is even properly here before this court based on the trial court's denial of the 60B. Excuse me. Because the denial of the 60B is what was appealed, and they're arguing all sorts of additional arguments now that don't even apply to the actual issue that was being appealed.
I think maybe where some of the confusion comes in here is that you refer to stipulation 10, and that speaks to only the properties held by Hillgrove LLC. And it's my understanding that there were 4 properties held in Mr. Hillgrove's name, but not in the LLC.
That's correct.
All right, so I understand what the stipulation says, but it appears that there was confusion on behalf of Mrs. Klug concerning which properties actually were in the LLC. Do you understand my question? That's not really a question, but it looks like the stipulation concerns only this LLC, and there are properties in there, and yes, they'll be sold, everything's going to be divided, but then there's these properties out here in the husband's name that are not included in the LLC. And at least in my mind, it seems that that's maybe where the confusion came from. My understanding is those properties were held solely in his name. Am I correct in that or not? Okay.
That's correct.
All right.
The 4 properties at issue here are solely in Mr. Hillgrove's name.
Right, but I can't see any mention of those properties anywhere other than what appellant's counsels indicated during the trial. I don't see those properties anywhere else in the decree or elsewhere. Is there anywhere where you can find those?
The only place that I can certainly point to is I know during that trial, there was an exhibit list included, and appellant's counsel included those 4 properties as exhibits LI through 1I through 1L. So they were made part of the record through the exhibit book. They were admitted through the exhibit book. Outside of that, the testimony during the trial, I am not familiar with. I wasn't there.
Yeah, you just came on.
But the law doesn't require that these properties somehow be dealt with in the final decree in some manner, either by the judge saying these are his separate property or they need to be divided. I mean, they were just omitted here, right?
That's appellant's position, that they were omitted.
And
Our position is they were discussed during negotiations between the parties and their counsel. They all knew that the properties were titled in Mr. Hillgrove's name. Appellant knew that.
But that's not on the record.
Again, I can't say what was testified to at the trial. I can just, as where I stand today representing Mr. Hillgrove, it's our position that the 60B was properly denied by the court due to the fact that appellant failed to follow the proper procedures of objections and appealing the decree.
And you agree that it's a final order, even though that order did not deal with all of the marital property?
Absolutely. And just to respond to the information regarding the values of these properties, those values are not correct for purposes of settling. Even if this were to go back, it's true that one of the properties did sell for $255,000, but during the marriage, that property was completely gutted. Mr. Hillgrove utilized his own funds after the marriage, after the divorce, to rehab the home and sell it. And that's what kind of brought all this to light, is appellant saw this online, saw what it was being listed for, and then decided she wanted to be a part of the sale. But that's not, when you take out the expenses that Mr. Hillgrove did alone, that is not what she is entitled to. In addition, the other 2 properties, one is premarital, does not even, it's in Mr. Hillgrove's name, but someone else is living there and someone else we can show put the funds down for it. It's just in Mr. Hillgrove's name. And the other two, quite frankly, are not worth hardly anything. One has a squatter living in it. There's no value to it whatsoever. And the one that he sold for $25K took a $15,000 loss because he put $40,000 into it just to get it sold. You know, so she's arguing for issues, thinking she's going to get money, where my client's point is he wants the divorce to be final. He wants this to be over. He doesn't want to have to keep dealing with this, but because appellant believes that she is entitled to some type of funds, we keep coming back on issues that, in our opinion, have already been resolved and are final.
Not to beat a dead horse here, but it wasn't resolved, though, because there was no mention that, as Judge Krause keeps pointing out, it was completely omitted. It's not like, you know, it's not like Ms. Klug disagrees with the disposition. It was just completely omitted.
Again, I don't believe it was completely omitted based on my knowledge of the case.
But it wasn't in the judgment. It doesn't matter what happened
That's
below,
correct.
but it wasn't actually, the trial court omitted those properties from the judgment.
The trial court did not address those 4 properties in the judgment. That is correct.
Okay, thank you.
Any further questions? Thank you.
Thank you. Ms. Wade, you have 3 minutes.
All right, Your Honors, just briefly, I would like to point out an important factual note. There were not 4 parcels titled in Mr. Hillgrove's sole name. There were actually 6 parcels titled in his sole name. The parties entered into their stipulations prior to the 3rd day of trial, and one sentence in Stipulation 10 states that if husband can trace the premarital value of any properties, he shall retain the premarital value free and clear of any claims of wife. Prior to the 4th and final day of trial, he did in fact trace his separate interest in 2 properties. That's 11 Cincinnati Avenue and 11 Miami Avenue. They came back and specifically excluded those 2 properties from the marital estate, and those are in the decree. And those were highlighted as being separate property, not because they were titled in his name, but because he conducted the tracing that was contemplated in Stipulation 10. When the decree was filed, those 2 parcels are specifically listed, and all other parcels are supposedly supposed to be incorporated into Stipulation 10, except that they are to be sold and proceeds equally divided. So the decree itself gets rid of that opportunity for Mr. Hillgrove to do further tracing. He did his tracing. He found those 2 properties to be separate, and the decree is silent as to the 4 remaining properties. So it is, again, our position that because the decree is silent as to those 4 remaining properties, they were not disposed of as required by 3105-171 and Rule 75F. The decree needs to be finalized. This matter needs to be sent back to the trial court with instructions for those 4 parcels to be reallocated. Ms. Klug is not seeking to a second bite at the apple to object to anything that had been included in the magistrate's decision or had been included in the decree. We're not trying to open the door to the whole divorce. We simply want to address these 4 parcels that were not addressed originally, and they should have been. And that is all that we have. Thank you very much.
Thank you. Thank you both for your arguments today. We will take the case under submission and issue a timely decision. Thank you. The next case is State v. Palmer. Good morning, Ms. Adam.
Morning, Your Honors. May it please the Court, Mr. Hoffman. I'd like to reserve 5 minutes for rebuttal, please. Obviously, since I'm filling in at the last minute here, I would just like to offer some highlights from the brief that was submitted by the state already. It's our position that what we have here in the record establishes that there's potentially useful evidence versus materially exculpatory evidence. And certainly what factually here we have 3 officers that respond to a scene, and the officers whose body-worn camera is at issue here was the 3rd officer to respond. We know that the first 2 officers arrive in the same car. One officer doesn't even exit the vehicle. The officer who did exit the vehicle and had some correspondence with the victim, in this case, his body-worn camera was activated and was provided. So what we're talking about here is the potential evidence that could have been provided on a body-worn camera from that 3rd officer who responded, who may or may not have actually activated his body-worn camera. So we don't, number one, we don't know that it actually even exists. And then number 2, we don't know if it did exist, if it was something that, just a glitch that occurred in preserving it. But I think if we look at what establishes more than anything is that this is potentially useful evidence as opposed to materially exculpatory evidence. That was provided actually in the defense's own argument in support of their motion, was that, well, we don't know if the victim could have, in that brief amount of time that 3rd officer was with the victim, that maybe that victim could have said, oh, yeah, I made the whole thing up.
Counsel, isn't, because trial counsel, the defendant's counsel, sought or moved to preserve the evidence, correct?
Correct.
Yes. So the burden then was on the state to show that the evidence was solely inculpatory, not, the state had to show that there was absolutely no exculpatory evidence, correct?
There was
According
not
to the
materially.
Anderson case, the burden was on the state to show the solely inculpatory evidence or value of the evidence.
Correct. And I think the distinction that was made between those other cases, the case law that was provided, is that the moment in time that we're talking about here with regard to what could have even potentially have been captured on the body-worn camera was just interaction with the victim after everything had occurred. This is not an OVI matter where, testing or you have the stop or you have, the testing going on. This is all completely after the domestic violence offense would have occurred.
It's the victim giving a statement of what happened.
Well, not even actually a statement of what happened, because and we have this provided in Officer Wilson, who is the officer whose body-worn camera is at issue here. He testified that he was there at the same time as the officer whose body-worn camera, and I believe it's Mandela, Officer Mandela. They were there at the same time. The victim was actually being treated. And that goes to the other portions of this that the state pointed out, that the defendant was able to obtain comparable evidence to what could have potentially been involved if we knew that Officer Wilson's body-worn camera even existed, or that recording.
I'm confused. I thought there was a period of time where the officer whose body-worn camera doesn't exist anymore was alone with the victim. It wasn't, there were 2 officers recording at the same time.
There was a brief, I believe Officer Wilson testified that Sergeant Mandela left shortly before him. But it wasn't that he was alone. We also have paramedics were at the scene as well. And then that's when all of the victims, everything that transpired between the victim and the officers were at the time that he was being treated by paramedics. So, and I believe that the testimony of Officer Wilson too was, the purpose wasn't necessarily, it was the description of the suspect. That was the information they were getting.
That was the information that was not recorded.
That's what he said that transpired between,
Yeah, I'm
based
just
on
trying
his
to
memory.
figure
I
out
don't know
what's
that.
missing. What's missing from the body-worn camera is an interaction with the victim, and what did people say the victim was saying at the time?
Correct, that could be the
We don't
only
know.
thing and Officer Wilson provided the testimony that's, his interaction with the victim was just for that, and he, said it was just shortly, he only stayed for a short amount of time until he was being cleared by the paramedics,
Wasn't it
so we don't know
15
that.
to 20 minutes? I think, I have written down that it was 15 to 20 minutes.
I think that was his total interaction with the victim, including what would have been on Sergeant Mandela's body-worn camera as well.
Okay.
So, and again, there's comparable other evidence if we want to talk about, what the body-worn camera would have shown as far as injuries go. We have, paramedics that were also at the scene. This isn't a situation where Officer Wilson was completely alone with that victim. So based on all of that information and what's available in the record, the state believes that they did establish that this did not involve materially exculpatory evidence.
Just because there were paramedics there doesn't mean that the paramedics were paying attention to what was being said or were, could give any testimony about what transpired that was missed on the video.
And it goes both ways.
No,
but because
you had the burden, though. I mean, the state had the burden to show that. So, I mean, why, I guess I'm struggling to understand why there wasn't additional testimony about what the paramedics could tell at that point.
Well, and I think that goes to the later point made in the state's brief, too, that this did appear to be a very hastily conducted hearing, and the state was only cross-examining Officer Wilson at this hearing. So if the court would be so inclined, we would ask then that it would be appropriate, as opposed to a dismissal, that it'd be appropriate to remand for additional evidence to establish that this was not materially exculpatory evidence.
Can I ask, so this is where I'm a little confused on the record. My understanding is there was this motion to preserve, and the defense kept coming in for court dates saying, where's the video, where's the video, where's the video? And the state kept saying, I'll get it to you. Like, that it indicating that it existed at the time. And so my question is, what actually came out? Did the video exist earlier on and then it got destroyed, or
And
what happened?
based on my very limited, with an hour before we came here
Yes.
today, knowledge in the transcript, I don't believe that we ever knew that. The officer simply couldn't recall whether or
couldn't
not
recall
he
if he turned it
activated
on.
his camera.
But there's a period of time where it's saved and then it gets destroyed, right?
Generally, you
Yeah,
mean?
the body-worn cameras.
That's my understanding. And again, this officer, this is a patrol officer, this isn't the sergeant. Based on his limited knowledge of the process as well, is that there's something that occurs to connect when you have multiple officers obviously responding, and this, the technology involved in that, I'm not obviously privy to it either, is that it would at some point connect. So he doesn't know, do you surmise from that? He's assuming that, well, whenever I get out of my vehicle and I'm going to interact with someone, I activate my camera. I don't know. Was it malfunctioning? Did I forget to do it, or did it happen after the fact?
But we can't tell from this record whether it existed at the time the defense filed their motion to preserve. And then somehow, for whatever reason, the state came back and said, we'll get you the video. It got destroyed in the meantime. There's nothing in the record that.
Again, from my limited knowledge, and again, too, I think there could be some confusion because there obviously was, at least Sergeant Mandela's body-worn camera was presented, and I don't know where in the process that was made available to them. So whether it was confusion over, there being multiple officers and multiple potential recordings, I don't know. And I don't know that that's set forth in the record either. And I'd like to reserve the rest of my time. Thank you.
Thank you. Mr. Hoffman?
May it please the court, Ms. Adams. The state did not eliminate the possibility that the missing evidence was helpful to the defense. It was their burden to do that. The state did not prove that the missing evidence was it was not materially exculpatory. And the only argument that's made before this court is that the officer had recorded on his body-worn camera events that took place after the occurrence of the alleged offense. And I want to point out that nearly all body camera footage that's investigatory is going to record events that or statements that are made after the offense occurs. And so if that argument were valid in this context, then it would be a basis for finding that missing evidence was not helpful to the defense in all kinds of cases where evidence, body-worn camera footage would not be disclosed despite a motion to preserve, and there'd be no recourse.
Well, Mr. Hoffman, aren't most of the cases similar to this, where body-worn camera is missing and courts find that the state failed to meet their burden? Aren't most of those in an OVI context?
Some are, but I don't think so. I couldn't say. I'm not able to say.
What you're really, I mean, what you're arguing here is that there was a potentially recorded discussion with the victim in this case, right?
Correct.
Okay, and then that could have potentially been useful in maybe cross-examining the victim later on their version of the story if it conflicted?
Well, I guess to be more precise, I'm saying that the state didn't disprove. They did not disprove that it could be potentially useful. I really don't know anything about this recording. I do know that the state didn't prove that the state didn't eliminate the possibility that it could have been helpful. I think that's an important distinction to make, because once the burden shifts, it almost determines the case.
Well, I mean, they argued that the recording would have just been of the officer talking to this victim when the victim was getting medical treatment, right?
Right.
Because the officer testified that that's what he did. And so I'm just trying to understand how that potentially could be materially exculpatory versus potentially exculpatory.
Well, I guess that would be a concern, but it's, again, I think that's a different, it's not my place to argue that.
It's not your burden.
Correct. And I think it all falls on the shoulders of the prosecutor to argue that there's nothing there that can help, and it can't be done when you don't have the exhibit. And the reason why we don't have the
Mr. Hoffman,
exhibit.
let me ask you this. Based on the transcript, there's a question. Number one is whether there was ever any recording of the interaction between the officer and your client. The second is it was recorded and somehow was lost. And you're not arguing bad faith at all, are you, on the part of the officer?
No, only the sequence of the filing of the motion to preserve, and then the fact that the exhibit is
Just
not.
assume it was there.
Yeah,
and somehow
right.
was lost.
Right.
Okay.
That's what I'm
not bad
arguing.
faith.
I'm not arguing some bad
So
faith.
wouldn't you be able to find out what was said by the prosecuting witness while he's being treated by the paramedics in the presence of the officer, by cross-examining the officer once he's under oath? Wouldn't he have an obligation to say, oh, yeah, during this interaction, he said, oh, yeah, I made it all up, or something like that? I mean, there's speculation, but by the same token, after this interaction with the prosecuting witness, after the officer spoke to him, the officer went ahead and signed domestic violence charges on your client. Is that correct?
That is correct.
All right. And weren't there other witnesses to this hammer attack while it was going on? My understanding was that apparently, according to the affidavit filed by the officer, who either didn't record or recorded and lost the tape, that the defendant's sister held the prosecuting witness while he was being struck by the defendant with a hammer in the presence of other people. So wouldn't you be able to potentially get useful information from those witnesses that said, oh, he wasn't hurt, or it didn't happen, et cetera, instead of just depending solely on this interaction with one officer who shows up after it happened while he's chatting with paramedics? I mean, aren't there alternative means to get what you want?
If the state could have availed itself of that, yeah. The state also, at the March 1st hearing on the motion to compel, could have asked the officer if anything was said beneficial to the defense, in his opinion, or what was said exactly, and it wasn't done.
And I've read the transcript, and I understand what you're saying.
Go ahead, Your Honor.
Mr. Hoffman, are you finished, Judge Winkler? I'm sorry.
Yeah.
So the trial court actually dismissed the charges
That is correct.
instead of suppressing the evidence, which it could have done, correct?
Well, I'm confused now.
Okay, I'm sorry. So instead of, never mind, actually, forget that question.
Just going back to your, so you're not arguing bad faith, because there was part of your brief where it sounds like you almost are, in a sense, that there was this motion to preserve that was filed, and there's some sort of insinuation that this video maybe existed at the time of the motion to preserve and then was subsequently deleted. But that wasn't established or on the record or anything, right? We have no idea what happened with this video, right?
There was some circumstantial evidence that it might have existed from the March 1st hearing. Patrolman Wilson did testify that he testified to habit evidence, so to speak, that it was his habit to use it, and he could think of no reason why it wouldn't have been done in this case. So he did say that. But all the timeline, I think, goes to the inability of the state to effectively claim that this exhibit never existed. I think the state should not be heard, excuse me, to argue that there's a possibility this never existed when it was their own delay and looking into this that made it impossible to tell.
But doesn't that kind of go to like a bad faith argument, in a sense? That there would have to be some sort of determination that because the state delayed and it ultimately got destroyed, that was bad faith?
I think under Anderson, it's not necessary to argue bad faith. I think you can just very objectively say that you have a motion to preserve evidence filed that's specific and a demand for discovery that's specific. And during that time, this body camera footage would have existed. And by the time the motion to compel hearing was held, the officer testified there's no way it would have existed by now.
But that's the problem. We don't know if it existed because the officer testified that maybe he didn't turn it on. I mean, there's nothing that's established that, yeah, it existed at this point, and then ultimately it was deleted. It's completely unknown what happened with this, right? So.
But we can't be, it just doesn't make sense to remove the remedy that is due to us because of that, when it was the state's delay that made it impossible to tell whether it ever existed. If the state had acted on this, the state did respond to the motion to compel in 12 days, but their response was incomplete and irrelevant.
We don't know
almost.
if it was the state's delay. It could have been an officer mistake that he didn't turn it on. You see what I'm saying? Like, there's no indication that it definitely was the state's delay that caused this video to go missing on the record.
There was a lot of delay in the case, and there was a lot of, the transcript seems to say that it was Mr. Nazarene and not the prosecutor who prompted and came up with specific items of evidence that were owed him that existed. 911 call, the witness's written statement, Officer Mondillo's body camera footage, all that was mentioned by defense counsel and not the state. And then the state came up with it after it was mentioned. I think there was a delay here. There was a substitution of prosecutors and.
Yeah, there was a delay for sure, but the delay lead to the video being destroyed is the question.
Well, that's sort of in the same category. We'll never know. And we'll never know because of the piecemeal response to the prosecution's, to the state's defense request for discovery. And because of that, we should not be held responsible for the inability to tell what happened or whether it ever existed with regard to the body camera.
Mr. Hoffman, I'm going to go back to a question that Judge Winkler was asking. So if the state proved, if we determine that the state showed that other witnesses could have filled in this information, I mean, particularly, there were witnesses who saw the alleged attack, and then there are paramedics who could testify to the injuries themselves. I don't think the identification of the attacker is in question here, correct?
This is not a question of identification, that's correct. The
Okay.
victim was able to identify his
Okay.
assailant.
So
apparently.
if we have evidence that this person, if we have a lot of people saying that your client did this act, and the paramedics and the doctors can testify to what the injuries are, I'm struggling to, I'm hoping that you can explain to me how this is materially exculpatory versus potentially useful.
Well, one scenario might be self-defense. I mean, it could be. I'm just thinking that it might be the alleged assailant might have been acting in self-defense, and there might be suggestions to that in the statement made that might have been recorded and then the recording destroyed. I don't know. But it was up to the state to prove all this. It was up to the state to nail all this down, and it couldn't be done. Once that burden shifted to the state, it determined just about everything. This is missing evidence. It's gone. Whether it existed or not, we can't tell because the state delayed in trying to get this thing discovered. And I think that a case-by-case determination of the exculpatory nature of the missing evidence might be possible, but it's up to the state to eliminate the possibility that there would be exculpatory evidence, and they were unable to meet the burden here. And I think they had a chance, too, at that March 1st hearing. I think a remand is not called for. Officer Wilson was the best person to talk about, to elicit evidence from as to what that conversation entailed, and they didn't ask a question about it.
They didn't ask him what the conversation entailed?
No. They asked him about whether the recording existed, whether he used his camera, whether he didn't, what happened to it, whether there was whether it was miscatalogued, whether it could have been recycled.
So it was all focused on what happened with the recording, but not
Exactly.
about his interaction with the
Exactly.
potential witness?
Exactly, and it could have. And they're asking this court now to have a chance to do what should have been done then. And the remand is not called for. So if there are any further questions, I would ask that
Was there any testimony during the March 1st hearing about witnesses other than the paramedics witnessing? Well, okay, the paramedics weren't there yet, but was there any testimony about people witnessing the attack? I know that there was testimony about another video, correct? That somebody took, but that was missing, because that was a witness video.
correct.
Okay, so there was testimony that there was at least one person who witnessed the alleged attack, correct?
I guess it could be assumed, yes, because if he recorded it, but then it wasn't given to the police, it
Right.
remained in a private person's hands.
Right.
So the state couldn't be responsible to disclose what they didn't have.
Okay, thank you.
Thank you, Mr. Hoffman.
Thank you.
Unless the court has any further questions,
I don't.
Nothing else?
Thank you.
Thank you. We will take the case under advisement and issue a timely decision. The next case is State of Ohio versus Pitts. I believe Mr. Hoffman is now the appellant.
I should have gotten Hollis to stay there.
Yeah, that wouldn't be nice. Whenever you're ready. I know you got to switch gears.
Yes.
Would you like to reserve any time?
5 minutes for rebuttal, please, Your Honor.
Okay.
May it please the court, Ms. Steer, I represent Mr. Gregory Pitts in this case, and I wanted to discuss the element of causation under the sufficiency claim. This particular subsection of the resisting arrest statute calls for evidence that the person being arrested caused an injury to the officer in the context of the resistance, and that elevates the seriousness of the offense. But it's an offense in itself. It's not a aggravating element. It's the element of that crime. And causation is defined in Ohio in the criminal law context as it is in the civil context. It's a two-part test for whether you can, for causation. And the first is a actual cause or cause in fact. And that test is met, it's a but-for test. And it's a relatively easy test to make. And the second test is a proximate cause test. And so in the criminal context, people aren't responsible for things they cause remotely. It would be a direct cause. And in the natural course of events is the way the jury instruction reads. And in this case, the police officer in the case, Officer Michael, went to the residence at 7954 Seward Avenue, and the residence of Cecilia Pitts. And she was outside the house complaining that Gregory Pitts had shoved her, pushed her, and poked her in the head. And the door was locked, and she gave the police the key to the residence. And Officer Michael approached the residence, opened the door, and called for my client to come out. And he did not come out. And Officer Michael and other officers pursued him inside the house to, I think it was the dining room. And it's a hardwood floor, no carpet. And Mr. Pitts had anchored himself under the dining room table. And after a warning, Officer Michael took out his taser. And on the body cam footage, you can see that it didn't work. It either ricocheted off a wall or the table, and you could actually see the probes on the floor by his feet connected with the wires. And there was a struggle to handcuff my client. And in the course of the struggle, Officer Michael had to kneel. And when he kneeled on one of the probes. And it punctured the skin on his knee. He wasn't aware of it until after because of the adrenaline and all, until after the arrest was accomplished. And that's what happened. And I'm arguing that event, that injury to the officer was not, that the resistance in this case was not the proximate cause of that injury. It was remote. It was not in the normal course of things for the officer to receive the probe and not the person being arrested. And because it's unusual like that, it's unexpected. Because it's unexpected, it's not the proximate cause. So my client shouldn't be responsible for that. It's an occupational hazard.
And why was it unexpected? I mean, he shot your client, or shot a taser at your client and missed. Wouldn't it be expected that those probes would be lying on the floor somewhere?
Yes, and officers do miss. I mean, it does happen that they miss people.
Right.
It's just that the reason for these guns, these tasers, are to shoot the person being arrested. And they usually don't find their way to the officer, and that's what's unusual about it. And so it's just unusual that the officer would get the probe and not the person being arrested. And I think that is unusual.
If the officer had hit his head on the table and caused a huge gash in his head while he was trying to get your client out from under the table, would that have been proximate cause?
Probably it would have been found to be proximate cause because it was in the course of the struggle that he would have hit his head.
Didn't he kneel on the taser in the course of the struggle, though?
Mm-hmm.
I'm just trying to
No,
differentiate.
I could understand. I guess it could be, but the fact would remain that it's a taser probe and that the taser is usually used to subdue the arrestee and not the person conducting the arrest.
Mr. Hoffman, watching the video, and I only watched it once, I'm sure you watched it more than me, so if you could clarify, it appeared that your client was he was hiding, he was flailing a bit during the struggle, and, I mean, the fact that your client was flailing like that, couldn't that suggest that he should have known that his flailing while he was resisting might cause something like this? I mean, it's hard to get a moving target, and he was definitely moving.
He was moving, yes. The interesting thing about these probes is the laser light. You can tell what you're aiming at because it illuminates, the laser light illuminates the object. And I understand, I'm no expert on these tasers, but it looks, from the videos I've seen, it looks like the officers try to aim for the back, the person's back, to shoot them in the back. And so if the person's rotating at the time, I guess it could make it difficult. But whether a citizen is aware of all this, I don't know. I kind of doubt that would be something in the back of his mind at the time he's trying to resist. It looked like a lot of the video was an attempt to free his arms. It looked like he was keeping his arms in front, and they had to get his arms behind him to handcuff him, and that seemed to be the most of the trouble in the case. At the time he was warned, one officer used the taser without warning, apparently, but Officer Michael repeated the word taser 3 times before he fired. And so that would put the person on notice that he's about to get tased. But I can't remember whether he was twisting at that time. He might have been. He certainly was hiding under the table. So that's about all I can do to try to answer your question.
Thank you.
You're welcome. That was the extent of my argument. I think that there was insufficient evidence of cause. And when you don't have sufficient evidence for any element of an offense, the remedy would be a discharge, a reversal and discharge. And in this case, the evidence is insufficient to prove causation, and I would ask that the court would reverse and discharge. Thank you.
Thank you. Steer.
Good morning, Your Honor.
Morning.
Mr. Hoffman, may it please the court. First, for that last point, we definitely do not concede that the injury to the officer, the cause of the injury to the officer was not proven, but if it were not proven, it would not be a discharge. I think that you could find him, you could enter judgment on the lesser included of no harm to the police officer, so it wouldn't be an automatic discharge. But as for causation, we believe that we've shown that he did cause the injury to the police officer as a result of his resistance or interference. I think Judge Krause, you gave the example of him banging his head on the dining room table. I was thinking, as I was sitting there, if he had broken some glass, and I'm not sure, I can't remember from the video whether there was glass. I know that there was things broken. Had the officer knelt on broken glass, I think that we would say he caused harm to the officer. Here, because it was a taser, in some respects, it makes it worse because the taser wouldn't have been out had it not been for Mr. Pitts' resistance. But I think that something like, it's just the way that he's thrashing around in the video when you watch it, someone's going to get hurt.
Well, it sounds, the statute's written where, there's resisting arrest, and then if you really resist causing injury to the officer or do something that the officer ultimately gets hurt, then it's a
Correct.
higher penalty.
Correct, I agree. And I think in this case, it's clear that Officer Michael was hurt as a result of Mr. Pitts' resistance. If I could just go back to the rest of the assignment of error, it seems as though maybe Mr. Hoffman's kind of dropping whether or not Mr. Pitts knew he was being arrested. it's clear he knew he was being arrested. When you watch the video, he says, as soon as they ask him to come down, he says, "No, because last time y'all took me to jail and I didn't do nothing. I'm not doing that again." And he said, "For what? What are you going to do? You're all going to try to take me to jail." And then, I don't know how many times he said, "I didn't do it, I didn't do it, I didn't do it." Clearly, he knew he was going to be under arrest. And also, Officer Michael testified that he was going to put him under arrest. He had decided to make an arrest. It's clear that the police officer doesn't have to say you're under arrest to institute an arrest. And Officer Michael saying that he was going to make an arrest, that's what kind of makes it different from State v. Carroll that was cited in appellant's brief. Because in that case, the officer was not going to arrest him, I think, until he started to run away. And then the third point I wanted to make is as far as probable cause to arrest. In his reply brief, Mr. Hoffman suggested perhaps Officer Michael did not have probable cause to arrest, but it's clear that he did. Under Revised Code 2935.01B, a police officer can make an arrest without a warrant for an offense of violence based either on the police officer's personal observation or on the statement, Lampe, State versus Lampe, 2003, Ohio, 3059. They said a written statement was sufficient for an officer to make an arrest without a warrant. Here you have the mother's statement. Granted, what she's saying, I think this woman has some disabilities herself. There was some suggestion during the trial that she maybe has Alzheimer's. She said that he poked her in the head, he pushed her, he shoved her. I think she says he hurt me. And Officer Michael was familiar with these. He had been called. This had happened repeatedly, so I think he had more than reasonable grounds to effect an arrest, and that's what he was trying to do when he was resisted. So we'd ask that you affirm. Thank you.
Thank you. Mr. Hoffman, you actually have 9 minutes.
Thank you. It might be that the officers intentionally downplay their intent to a person potentially to be arrested by not saying out loud they're going to arrest, you're under arrest, we're going to arrest you. But be that as it may, in this case, the officers did only say that they wanted to talk to Mr. Pitts initially. They didn't even want to enter the house. They wanted him to come out and just talk. And when a person talks like that, it's sort of, when a police officer says that, it's sort of an indication that their intent is not to arrest. If they wanted to arrest, if they were behaving as if they were going to arrest, they would have charged in and just started apprehending the person. But instead, they tried to talk him out of the house. And so that behavior, I'm arguing, would tend to indicate to a person that there is not an intent to arrest at the time. And so that's what I was trying to get at as far as the elements of an arrest, that they weren't met because of the officer's initial conduct when they tried to say that they only wanted to talk. So I believe that it could be found that there was no arrest here until after the apprehension, and the resistance did not take place until after the arrest. It took place before the arrest was accomplished. So if there are no further questions, I'd ask that the court would reverse. Thank you.
All right, thank you. Thank you both for your arguments. We will take the case under submission and issue a timely decision. And that concludes the court for today. I hope everybody has a great afternoon. Thank you.
Thank you.
And for the students, I think you guys can wait in here and we'll be right back out to talk to you. All right.